All right. Welcome everybody to week bajillion. Again, Gary probably knows better than I do what week this is. Jack probably too. He's probably Googling it in the side right now. But Gary had to have emergency eye surgery. I think his retina became detached, which is a problem that he had before. So hopefully he is going to, well, I know he's going to recover okay, but we wish him well, which means that he left Jack and I to our own devices here. So Lord knows what's going to happen with this. But for this week, we're hopefully going to be able to round out a discussion on uh, commercial property leases. I will try not to lose my temper during the meeting. There's only two topics that have a high degree of likelihood to cause me to lose my temper. And one of those would be our health insurance renewal. And the second would be dealing with our landlord. So I will try to restrain myself because, like, in both cases, all logic leaves the building in terms of what seems to be reality. So anyway, looking forward to it. The only thing before I turn it over to Jack, the only thing that I had for this week is that, we have had a lot of people that have ask questions about the bipartisan tax legislation that passed that included a couple nuggets, two that were primarily relevant for our client base is that, one, they fixed the research and development credit problem, meaning you could expense research expenses and still get the credit, which is great. And then the second is they extended bonus depreciation to cover 100% versus what it had reverted back to. So, that was great news in the sense that it passed the House with bipartisan support. It also included a child tax credit provision, which the Senate isn't super keen on. So, a lot of speculation, in the Senate, like, it's going to die. Like the Republicans in the Senate are against, some Republicans in the Senate are against it, like enough to filibuster it. So it actually hasn't gone for a vote, but currently there's belief that the votes wouldn't be there to pass it, even though it was, bipartisan, like a post office naming bipartisan way, not fake bipartisan way. So we hope that they get off their duffs and actually pass something. But that's a long way of saying that, I had a client that sent me an email the other day from their aircraft broker Jack, as one does. Says, great time to buy a plane. There's 100% depreciation, and he's like, it's time to pull the trigger on the corporate jet now that I got corporate jet money. And I'm like, well, they sort of got the facts wrong there. It's always fun when airplane brokers play tax professionals, but this isn't quite why yet. So anyway, hopefully it does become law. For people that had the research and development credit, we have held off on those returns. If it was otherwise going to be, something where we wanted to take advantage of depreciation, we can always amend for it later to catch up the depreciation. So we're not as concerned about getting people done on time for that one. So anyway, also just a reminder that Monday is a tax filing deadline. Contrary to popular belief, if you bring your stuff in a shoebox right now, I'm not going to get it done. Sitting in front of you. So anyway, off to you, Jack.
But my shoebox has the stuff clipped together. So I have my
But
charitable contributions with a paper clip, and I have, my
yeah,
reimbursed business expenses. And
I haven't added any of it up. You'll be good. You can add it up on your 10 key right in front of me. It'll all be good. So
yeah, absolutely.
yeah.
Yeah, no, I get it. So Congress has been out for a little bit. They came back into town on Monday to conduct official business. So there hasn't been a whole lot going on, and they came back into dealing with things like the Baltimore Bridge and some other things and the usual things. But one thing that I want to share, because people have been asking me about it, is the new debt forgiveness plan. And I'm sure. So you said there's only two things. Before we got on here, you said, okay, there's only a few things that really get you riled up. I think this may be another one, if I recall correctly, which is basically the president, and this is not a political statement at all. This is just, okay, is it fair kind of thing. So last year, back last summer, if you recall, the president tried to basically offer, and this was part of his campaign as well. I guess that is a political statement. Sorry, I didn't mean that. But there was a promise that there'd be some debt forgiveness for people who have extremely high debt for college education for their student loans. And that didn't go very far because and I just learned this week that the previous plan of forgiveness relied upon the HEROES Act, which is a pandemic era stimulus package. And the Supreme Court said that that law didn't provide Biden the pathway to do what he wanted to do. So creative minds came up with a different way of dealing with it, maybe back to an older law, which is the Higher Education Act. And it allows the Secretary of Education to compromise, waive, or release federal student loans. And this is how he is putting forth this new relief program that is out there in the mix of things. And I can go through who qualifies, who doesn't qualify, but I guess, I don't spend a lot of time expressing necessarily my opinion on things other than, but in this instance, I feel like, okay, I understand the reasons for it, but, I guess because I'm closer to it, I have one student in college and one on the verge of going to college. And I'm like, okay, well, would they have been able to qualify for some of these programs that may have been more merit-based, quite candidly? And so, and this is really focused on not necessarily merit-based, but just income-based, but there's some things out there that are merit-based. And so why did my kids not get a shot at that? And other people are saying that as well. It's like, okay, wait a minute, why did my kid not get a shot at? Because there's a starting point, and so the ones that didn't get within the range of the starting point of when this forgiveness program, so when you incur the loan, are not going to be able to get the forgiveness. And so, it seems very arbitrary to say, well, and I don't know what the beginning point is. Is it the year 2000? Is it 2010? Is it 2015? When is it? So you have a lot of arbitrariness in this. And so that's really my problem with it, is not that, okay, wait, what about me? It is, okay, what about all of us who, are impacted by kind of the arbitrary rules that have been set up as starting, ending, and, all this money that's being put after the fact as forgiveness rather than applications for potential scholarships, essentially. So that's my little rant for the day, which is unusual. So, but so going on to the substance of stuff. So, Joe brought up something last week, a question that kind of boggled us and took us by surprise. So, the personalities that are mine and Michelle's couldn't let it go. So Michele looked into this, and it was in relation to whether you need to have something in writing in relation to a lease that has fingers that go out beyond a certain period of time and doesn't need to be recorded, or is it invalid? So Michele, if you want to kind of recap the question and provide the answer and kind of the guidance, that so no one else is taken by surprise.
Absolutely. So the question was asked if a lease that has a period over 3 years or more needs to be recorded for it to be valid, and the provisions of there certain provisions need to be valid. So a lease in and of itself does not need to be recorded. If there are provisions in the lease, such as right of first refusal or extension periods, then that lease can be recorded to preserve those rights should there be a change of ownership of the property. So if there's a change of ownership with the landlord assigns the property, sells the property and whatnot, then in order to preserve those rights that are in the lease, that lease should be recorded. This is a tenant benefit to have it recorded, not a landlord benefit. If there is an addendum done to the lease where any provision like that is written in, such as the right of first refusal or additional extension periods, in order for those extension periods and the right of first refusal to be valid, then that lease needs to be recorded, needs to be on record to preserve those rights. So I had mentioned last week that a lot of the leases have, and it's not the lease that gets recorded, it's the memo of lease that gets recorded so that there's record of this lease and those rights that are being preserved. And I'd mentioned last week that in most of the leases, there is language in there that says that the landlord or the tenant, lessor or lessee, have the rights to record the memo of lease. And that's the catch-all protection for the attorneys, the landlord, and the tenant. And when we are reviewing leases from the tenant perspective, this is something that's brought up that they may want to do this. Not everyone wants to, and in retail situations, it's not always necessary. So, I mean, if there's a specific question regarding that, I can go into more detail, but that's the overarching analysis of the statute that was referenced last week.
So to break that down for me, Barney style, if one was to record a lease, where does one record such a lease?
The leases get recorded with the registry of deeds, where
Okay.
your mortgage, your deed of trust, your deeds and whatnot get recorded, same place.
And like, is that something that shows up under, like, someone buys the property and it shows up under a title search somewhere that, hey, this thing is got a lease registered?
Absolutely. So that's absolutely why it gets turned up, because title searches pull defects, liens, and encumbrances on the property. And this would be considered an encumbrance on the property. So in order to convey if there's a right of first refusal and the prospective buyer didn't know that there was a right of first refusal, which goes back to something we had already discussed also, the right of first refusal last week. If the prospective buyer didn't know there was a right of first refusal, this would alert them when they did the title search. They should have already been made aware, but things happen.
Yeah. Okay. So this is where my temper can be quelled quite a bit. So thank you. Appreciate that.
And I will add, understand we're talking about recordings and public knowledge and everything else. Obviously, in a transaction, let's say you're going through a sale of a property, seller, buyer, current landlord, prospective landlord as the buyer, there will be due diligence that's being done. And there's also, and we've talked about this when we talked about asset purchase agreements and stock purchase agreements and everything else, there are representations and warranties that are put in there that basically you have the seller saying, this is my world. This is everything that's related to my employees, to my business, to my assets, to my taxes, to my property. And there is no right of first refusal or any other rights that impact my full, complete, unencumbered ownership, except as provided on Schedule 3.23 in the back. And then in 3.23, if there was a right of first refusal, it should be listed on there. Now, so that if it is not recorded, I just want to make sure that the perception is that you have to have this recorded or else you're SOL. That's not the case. There are other, and so it would be a breach of contract if you didn't disclose that. And so just keep those things in mind that, this is a way to make it of public knowledge that this exists. And it's not the end all be all as to if it's not disclosed that you don't have any rights because it wasn't reported, I guess is what I'm trying to say. So I think what I'd like to do is to and I will put things up on the screen through a lease, but we can maybe go through the anatomy of a lease and pause in certain places. So, for example, talking about the things as simple as what is the permitted uses, and then get into complicated things as to what should be and what should not be included in common area maintenance charges, and what landlords try to throw everything in there, and tenants should be a little more careful and thoughtful about what should or should not be in there, or at least negotiate that. So what I will do is I will share my other screen and let me know if the right one came up. I don't think it did. Let's try that again. I want to share screen number 2. All right. Can you see the first page of the lease on the screen? Okay. All right. So what you have is, actually, I'm going to put it in front of me, so I'm actually looking towards the camera. So what you have is, well, I can't do that because then you can't see what I'm doing. All right. Did it come back? Did I mess that up? It's on. Okay. All right. So, fundamental information. This is like the Cliff Notes version of what appears in the next 50 pages of the lease. So you have the fundamental lease provisions in here, what you expect to see, and they need to be consistent with what appears later on. And sometimes what we'll find is that there is an inconsistency that arises because this gets set kind of as like a term sheet. There are revisions that are made on page 10 of the lease in relation to something on here, and it doesn't get translated to the summary, the lease provisions. So that's the first kind of warning on that. You get to, and obviously it should be as descriptive as possible. I wanted to talk about permitted uses because this came up as to sometimes it can be, from a landlord's perspective, sometimes maybe too broad. And from a tenant's perspective, maybe too narrow. So you have an example, you have the premises shall be used for a doggy daycare. And so then you turn it into, or your services expand into grooming and into doing certain things. And you know that that's a possibility. Let's say you're a franchisee and you are not doing the full panel of services, you're doing certain ones and you expect to grow. This can be weaponized by a landlord to say, well, wait a minute, no, it says you can only do this one specific service. And when you go into ancillary adjunct services or adjunct products, that let's say you were serving pizza and now you want to serve burgers. Well, does it say a pizza place or does it say food and beverage? So those details matter. And I think that a lot of times we see that as white noise. I mean, just human beings. Lawyers don't. Our minds are poisoned enough to see that what it means is what it means and only what it means, kind of thing. So, but you need to think about words matter in things like this when you're talking about what you can and can't do, and that is applicable throughout the entire lease. So then you talk into fixed minimum rent. So you have several types of leases. You have some that have a fixed rent, some that have a minimum, some that have variable. So it's based upon a additional amount that's paid based on your revenue as a tenant, and all kinds of variations of that. And then additional rent. Here's kind of where I want to take a pause, Michelle. And if you would go through kind of the typical things we see as being okay, as being inclusive, and maybe some things that seem like, oh yeah, that probably is right, but maybe should be excluded. And an example would be is the administrative cost to a landlord for fighting to evict a tenant. Should that be part of CAM or should that be part of the landlord's operating costs? So things like that, if you could kind of just maybe put them in kind of two categories, just generally speaking, as examples.
So this is when we're looking at the lease from more of the tenant perspective, and it's a landlord drafted lease, they'll throw everything in there to see how much they can get covered or included into this additional rent. And the additional rent can include anything from, as Jack had said, the legal expenses to evict a tenant. It will include security. And then there are two parts of security. It's the security personnel, security cameras. It can be broken down in that way. Garbage removal will sometimes be in there, but not just garbage. There's like common area garbage. I mean, you have the common area maintenance charges there, but like there might be garbage removal for your specific unit. Outside of housekeeping, if we're talking about an office space as opposed to a retail space. There are so many different things. So Jack, I might need you to back me up on some of the other examples of additional things. Cause now I'm trying to go through it, like parking, which a lot of these things might be broken into their own respective categories inside the lease, but they'll throw things in those additional expenses or additional fees that are included into the rent, depending on how the lease is drafted initially. So
Yeah,
Trying
can
to
you
think of
see
some
this?
other
Can you
example.
see
I've
the
been going through so
screen?
many different leases lately that I'm like, what
Yeah.
are some things that I've seen in more, the leases in the last couple of weeks?
So
And
let
I've
me
seen
give
some
you an
ridiculous
example of that
things.
too. So talk about, okay, should you have a separate meter for electricity or
Mhm.
gas? And okay, you're not a restaurant, but you have a restaurant next door that's using a lot of water. So I mean, things like that, okay, is it common area maintenance or should it be? Because if it's common area maintenance and the water is included, you're getting a pro rata share based on square footage versus it being use. And so there have been cases where we have strongly suggested and required that a landlord sub-meter out something because we were being accused of using more than our proportionate share. And we said, until you show us that we are doing that, we're not going to pay an additional amount besides our pro rata share kind of thing, and vice versa. So you may want to talk about like sub-metering maybe.
Yeah, so well, exactly what Jack had just said, that and using his example of the doggy daycare, adding on an additional service with the water might be that you're now grooming and washing the dogs use more water. Or if you have a retail space where you're I'm trying to think of retail examples that are not just like restaurant. You might just be a department store or a clothing store, boutique, where your pro rata share might be minimal because you're not using anything outside of like standard business hours, your electricity and whatnot. But there are other services, other stores next door that would be sharing in them, and yours are going to be substantially less. So you would want your fees to be carved out to save yourself the money as opposed to being dispersed amongst the other tenants in the division.
Hey, Michelle, I'm just
Yeah.
asking for a friend.
Yeah.
So let's say hypothetically one was the anchor tenant in a building that was going to have retail space downstairs that was not filled when he became the anchor tenant, or she. I mean, it could be a she. It's gender neutral for this particular friend. And perhaps they just didn't know to answer that question and they're pissed off about their chem bills. Like what, because who would know? Like who would know, who would,
So
like,
you
what would I
don't
do in that scenario where it's like, hey, the restaurant space that's going to be using a lot of freaking gas isn't occupied, but when it is, I don't want to pay for their crap. you know?
if you have cause and you can actually show the landlord, then there's no harm, depending on the landlord. I say no harm. There's always, risk. Going back to the landlord and saying we need to renegotiate this. And the negotiations, and this is the lease addendums. There could be a lease addendum that says, okay, we have this other tenant now. You're an office, they're a restaurant, they're using exponentially more electricity, water. The utilities are just much higher for that business than yours. And you can show that yours are substantially less, which isn't always very difficult to do when the businesses are there's such broad difference. And there that's a way to bring it up and see if you can negotiate some things, which usually happens closer to the end of your lease term when you're renegotiating things, as opposed to if you're in a 10-year lease and you're in year two,
Yeah,
it might be a little harder to do that.
got it. Okay, fair enough. I'll duly noted for lease negotiations for this friend who may be getting close to hit the lease agreement being up in 2025. I heard, through the grapevine.
You can always refer them over to Shoemaker. I know a couple of attorneys there that would be happy to.
Yeah, I need somebody who can chew up somebody and spit them back out. So you're on it, Michelle.
And make sure that that person, whoever she or he may
Yeah,
be, understands that tenants these days have a lot of power. I think landlords might disagree, but I mean, because of the fact that there's options and because of the fact, as we've talked about previously, that the landlords were spending a ton of money on upfits and tenant amenities and everything else. We talked about, down on the third floor of our building that it's beautiful down there.
yeah,
And so that is and a lot of empty space, a lot of movement from out of uptown. So I mean, this person may not have that leverage because this person may already be outside of uptown. So, you know, those kind of things come up as well. All right. So let's talk about the lease term a little bit. And so negotiating lease terms and extensions and about what the pricing is going to be at that point. So maybe Michele, if you want to kind of maybe touch on, you know, as we're going through the negotiations and a client would say, well, you know, what should we be paying? Is it market? Is there a CPI adjustment? Or, you know, we obviously would like to know what we're going to be paying in year 11 if it's a 10-year lease and we have a 5-year extension. So, and then the counter argument, which is, well, landlords don't necessarily want to lock it down because, you know, what if they miss the mark on and they are giving their tenants not market rate, but something very below market rate. So kind of the push and pull of that.
So when you go through the standard schedule for year 1 through 10, assuming this is a 10-year lease, using that as an example, there'll be a percentage increase year over year. And then when you go to year 11 during that extension period, there are provisions within the lease that will allow for the renegotiation of the rent, and that's where the CPI is. Sometimes it's a CPI, sometimes it's a percentage, sometimes there's a dollar amount. But CPI is something that I think needs to be discussed more than the others because the CPI has fluctuated drastically over the last couple of years and has gone up pretty high. And if there's a CPI reference, and that's the number that you're going to be based off of, so your rent right now is $1,000, the CPI currently might be 8%. So now I don't do quick math, so I'm not even going to go there right now. When you're negotiating your lease, you want to cap your CPI. And this is where you might say CPI not more than 5%. So if the CPI is 3.5%, that's the CPI you're going to be resting at during year 11. And then you go, maybe there's a 3-year extension period. So that'll be based off of that number moving forward for the 3 years, that percentage and that base increase. Where if you're just at the CPI, and now the CPI on the particular year that you are negotiating this is at 8%, instead of being at the 3.5, you're now at 8 because there was no cap put on there. And with the CPI really having, and this is something I just looked up recently, the CPI really has fluctuated drastically. You want to make sure that there's a cap on there for yourself so that you are not in a situation where you're getting blindsided in year 10 when you're starting your negotiations for years 11 through 15. And now your rent goes from $1,000 to $1,500. And you're like, this doesn't even make sense to be in this space anymore. I can find a better space at this amount. So that's where that's important.
Okay. All right, next topic I want to talk about is repairs and allocation of responsibilities, but maybe, okay, you can go through what is a true triple net lease, what that means versus a non-triple net lease so that people understand kind of what that means or what it should mean. And then how, and then we talk about how at the end of the day, is it really a triple net lease based on the language? And I have some examples with relation to like HVAC and responsibility of repair in place. So if you could kind of maybe set it up as to what a true triple net lease is supposed to be.
So I'm feeling a little role reversal here, Jack, where I'm speaking a lot more than you are, and I don't know how comfortable I feel right now.
You shouldn't have told me that yesterday that I talked too much. You didn't say it that way, but I was like, okay, so.
No, not that you talk too much. I'm a woman of very few words, not most of the time, but sometimes. And I'm actually very appreciative that I can only see Adam and Jack on the camera, because if I could see all of the attendees, I might be even more nervous. I'm not the best public speaker, even though I am a lawyer and we do love to hear our voices. True statement, Jack, you know it.
Whatever, yep.
Okay, so there's straight leases, there's triple net leases, there are double net leases. There's I don't really know what I'm doing, and I don't want to have an attorney, so the landlord's just gonna draft something on a piece of paper type of lease. We don't like those leases. The standard lease you are going to get in this market is a triple net lease. Triple net lease is your base rent, your taxes, common charges, and maintenance. I think I messed that up, Jack. I don't have my cheat sheet. Taxes are your pro rata share of everything. So what do you, oh, insurance, that was the other one, insurance. I'm like, wait, I forgot something, insurance. So taxes, insurance, common charges, which are your maintenance and other things. So you have to cover your insurance for your space, and you have to cover a portion of the landlord's insurance. You have to cover, and I say you have to, but everything is negotiable and it depends. The common charges, which we touched on slightly, which we could go into a little more detail on what the common charges are. And Jack, you want to speak specifically about HVAC because that's a big one. Common charges, maintenance, insurance, taxes. So you have to make sure your place is insured. You have to make sure your taxes are being paid and there are no arrears on your business taxes or any sort of taxes that might attach to the unit or your business, and the common charges. So common charges, electricity, water, HVAC. What are you responsible for maintaining inside the dwelling, inside the unit, outside the unit, in front of, if you're a storefront, what are you responsible for? Generally speaking, you are responsible for everything inside the 4 walls or 20 walls of your unit. So if a pipe bursts inside your unit, if plumbing, something happens with your plumbing inside your unit, that is your responsibility to repair. If the neighboring unit's pipe bursts and it affects your unit, what does your lease say? And that's the big question mark. And that's what, these are things that need to be answered before you sign this lease, because there is no answer to that. Is it your responsibility? Because it did happen inside your 4 corners, but it was the neighboring unit's problem that started it. But was there a flood outside that now has affected your unit? That's something the landlord should have been responsible to repair. So that's where the responsible parties and outlining those responsible parties is very important to delineate in the written document. HVAC. Who is responsible for your HVAC? It's expensive. And how long is your lease? And how old is the HVAC system? HVAC goes generally, tenant is responsible for the HVAC or maintaining a maintenance agreement on the HVAC. Now the HVAC goes dead in year 8 of your 10-year lease. It needs to be replaced. Well, you're not planning on renewing your lease. Are you going to replace the HVAC system? What does your lease say? Does your lease say we are going to be responsible, tenant, we are responsible for replacing in full? Or did your landlord make sure that, or did your attorney rather, make sure that your lease said in year 8, it's going to be a proportion of the remaining term of your lease? So that's what we look at.
Yeah.
What does the document say?
Can you see, I put the screen back up. Can you see paragraph 9 on repairs on the screen? Is it, okay. So here, HVAC becomes a point of conflict a lot. And so we try to avoid that on the front end through a couple of ways. So as in this contract, it says tenant shall be responsible for maintenance, repair, and replacement of any glass, roofing, and exterior walls. And then tenant shall keep in good repair, maintaining, and replacing when necessary all electrical, plumbing, heating, ventilating, and air conditioning, and other mechanical installations. Again, this is a form, and we would go through and I would say, okay, that isn't sufficient if I'm representing the tenant. Why is it not sufficient? Because basically you see the words in good repair, maintaining, or replacing when necessary. Okay, there is a huge difference between repair and replacement. And a lot of times what we'll do is we will break this apart and say, okay, there are certain things that we understand that repair or replace, it's our responsibility because we are using that resource up, and then maybe we have to replace it. And we're okay with the fact that maybe we're replacing something in year 8 of a 10-year lease, and it has maybe an 8-year useful life, and we're only getting 2 years out of it. We're fine with that. With HVAC, I mean, that's a significant expense. So, to Michelle's point is that if you have to replace an HVAC in year 8 of a 10-year lease, and even if you have a renewal right, but it's not an absolute right, there is a possibility that you may not get that renewal for year 11, then you may have an incongruity in that you're paying for a brand new system and only using 2 years of a 10-year useful life. So how do we attenuate that financial burden? There are various ways to do that. One is to say, okay, that it is it's a shared responsibility, and there are creative ways to do that. It is, okay, if the new system costs $10,000, then we should pay probably, if it's $2,000 of that should be on us. And then if it gets renewed, then we pay more of that because we're utilizing that asset, but we shouldn't have to pay that. So, is it in the form of an increase in rent or some other amount that is paid in year 11 moving forward? Other ways are, okay, well, the landlord will pay for that asset, but you have to pay now for the maintenance costs and everything else related to that, not just a monitoring cost, but anything that is related to that. And by the way, tenant, there's a warranty related to that, so it's unlikely that you're going to have to pay for those kind of things. And that maintains control of that asset essentially within the landlord and who they're going to purchase from and things like that. So in the worst case is, and the best case for the landlord is that full responsibility is put on a tenant. I have had landlords, I've had clients that are very insistent upon that, and they say that is a cost of doing business. And the fact that you showed up at the end of the useful life of the HVAC, we've accounted for that in your rent, because if you had a new HVAC system, then the rent would be much higher, because we are trying to recoup our investment of having bought that air conditioning unit 5 years ago. So we can argue it either way and push forward on either perspective. So I don't want to say that, the tenant is always right. I mean, it just really kind of depends on the perspective. And if a landlord convinces a tenant and says that, okay, that's why your rent is more, or that's why your rent is less, or a tenant can convince a landlord that, why should I pay for a capital improvement on your property that I may not get the benefit of? So it really just depends. And a lot of that also is in the mix of negotiations. So let's say that you had to give in either as landlord or tenant on something else, you may not want to give in on this. Or so there's, all these negotiating points that interact with each other. And then the psychology behind it as to, okay, well, you brought up 10 things, I'm only going to let you win 50% of it. I mean, it's not as arbitrary as that, but there's also that influence going on in the back of their mind as well. So the repair section needs to be very carefully reviewed and put together so that as landlord or tenant, what your responsibilities are. And from my perspective and Michelle's perspective on repair and replacement, because those are two very different things. They get looped together. I mean, you look in this and you say, okay, any roofing and exterior walls, if the necessity therefore should be the result of tenant's negligence. Does the tenant's negligence apply to both roofing and exterior walls? Or does it only apply to exterior walls because that sentence participle, I don't remember my grammar or what it's called, but is modifying exterior walls and not roofing? So now we get into grammar. And should it say, and if the necessity therefore should be a result of tenant's negligence or willful misconduct or negligence in relation to roofing and exterior walls, then the tenant has to pay, kind of thing. So again, wordsmithing is important. I'm not trying to panic people, and please don't go back and look at your leases and be like, oh crap, mine says exactly that. And then you're thinking that you might have to replace the roof or exterior walls, kind of thing. So, or if it doesn't say that. So, okay. the next thing is I'm going through this, let's talk about environmental covenants. And so when you're going into a space, you should know and feel comfortable about what has happened prior to you getting to that space. So if you were taking on a space that was a restaurant and they used grease and stuff like that, you should feel comfortable that they did not dump the grease out the backyard or down a drain that is not meant for grease, that doesn't have a grease trap, etc. So, you should, as a tenant, be asking the landlord for certain representations as to the condition of the property. If they are not willing to give you that, then you should take it upon yourself to go have it inspected. So if there is a grease trap, I'm not suggesting that you as a tenant go do a phase 1 or phase 2 environmental study, but you should know those things. And quite candidly, I'm kind of suspicious if a landlord is not willing to give that, because they say, well, environmental, we don't want the feds to come down on us, and you have a claim if something happened that we didn't know about with a prior tenant. And then you get into discussions about, okay, as between me, new tenant, and you, landlord, who should be responsible for that? Should I, as a tenant? And I would say, as a landlord, yes, potentially. You can go kick the tires, you can go test the drains, everything else. You know that this was a restaurant previously or something else. And so, buyer beware kind of thing. So again, that's part of the negotiations back and forth in relation to that.
One more thing on the environmentals that I want to say that's very important. Under environmental covenants, there are usually also provisions as far or language that will say what you are precluded from using any hazardous substance, and there'll be a definition of hazardous substance depending on the lease and how it's written. You have to know the nature of your business and what you're trying to do there. There may be language in there that prevents you from doing what you need to do. If you're opening up a medical spa and you want to use certain, I'm going to say drugs because I don't know the right word, but certain types of drugs, injectables, so on and so forth, those like high-end med spas that, women of a certain age enjoy going to every once in a while. The language, the way the hazard, the preclusions you may not be allowed to do certain things that you want to do. So you need to make sure that your the definition of hazardous substance allows for you to do what you want to do with the purpose, the intent, your intent with that unit. So that's the other side of it. Not just what has already happened there, but now what you plan to do with the space.
Sorry, I had to unmute. All right. So
That's fine.
the next provision that I kind of want to talk about and see if I can resume the sharing is assignment and subletting. This is sometimes not talked about because it's okay, well, if you're assigning or subletting, something probably bad has happened or is happening, right? Okay, so we're not going to let you off, the landlord's not going to let you off the hook. And so you have to do something, you remain responsible for that, which is, kind of fair. The landlord has done their due diligence, they have vetted you, and they have an expectation that you're going to stay in the space for a period of time. So it's fair to say, generally speaking, that you cannot assign or sublet without our permission. A variation of that is, okay, well, we're not betting against ourselves, but we need to be in a comfortable position that if things don't work out, let's say you're a franchise, and let's say that the franchise just didn't work out. It was maybe not the best location for the products or services, or just, I've had one franchise owner who, and this is kind of a warning as well, totally random thought for you for your consumption today, but if they had looked at what was planned by North Carolina DOT, they would have known that their off-street access, their direct driveway, was going to be taken away from them because they were expanding the US highway and creating at a light, you go, and then you go behind the restaurant to get into there. And ironically, there was a restaurant that was closer than what patrons would have to do to go down to the stoplight and come basically a half a mile back to where that restaurant was, which was right near the interstate. And so at the time that happened, I had younger kids, and I said, I can see that happening when I have kids screaming in the back saying, please feed me, and I need to go to the bathroom. I'm going to stop at the closest place I can stop rather than going back a half a mile, even if I wanted whatever that product was, instead of what I was, stopping at. So those kind of things you need to think about as well. So there are things that maybe forces that are coming up against you that you may be able to do that. So my point is that you can possibly negotiate an assignment and subletting provision that says that even though it's in the consent and has to be consented by the landlord, put in factors that if they are met, then it is reasonable for them to consent to the transfer. A typical provision, I mean, well, okay. So Michele, why don't you share some typical provisions that we see as far as, being able to, I guess, a pre-consent to a landlord having to say yes to an assignment or sublet?
Some of the language would be the assignment. If the business entity is a family entity, so it's maybe parent company and it's one of the subsidiary companies, then it should be, we would draft it as though it would be an automatic consent to it because it's basically the same family. They've already gone through their checks, financials and whatnot. That's one, take that right off the top. And then reasonable consent for subletting. Nature of the business is the same. It's maybe the same franchise. So they have already vetted the franchise or the same type of business. Maybe now they're no longer going to be a franchise. Now it's just an independent, but similarly operated type of business that happens where the franchise has no longer ceases to exist or may have, whatever. Those are business things. That's Jack's side. The language that's always written in there is that the landlord will not unreasonably withhold their consent. So anything where financials may have already been disclosed or easily disclosed, you can't just say, hey landlord, I'm going to sublet to business A because I don't want this space anymore. You have to provide a package and explain why, but the landlord cannot unreasonably withhold because they just don't feel like it. They want to hold you to you're going to move and they're going to hold you to the rent anyway. So if they can fill that spot, that's why we do they cannot unreasonably withhold the consent. It always falls back to financials though. As long as they can pay for it, the landlord shouldn't withhold it.
Yeah, and then a lot of times landlords are faced with, and my franchisors do this, and most franchisors do this, which is it's called a collateral assignment of lease. So it's basically a franchisor saying, hey, franchisee, you need to have your landlord sign this piece of paper, a couple of pages, and usually it says that, hey, if this tenant screws up, our franchisee screws up, then we franchisor want to be able to step into the shoes of that tenancy and either operate a company-owned store or to flip it to a new franchisee. And you have to lease to that franchisee or to us without under the same lease. You can't modify the lease terms. You can't say no, kind of thing. And usually that gets negotiated to landlord, we're willing to tell, or the landlord says to franchisor, we're willing to tell you when your tenant screws up. Quite candidly, you're going to know if they're screwing up because they're probably not paying their royalty fees to you, franchisor, because they're not paying the rent to us. But okay, we'll tell you. We will also give you a right of first refusal if you meet the qualifications that we have in place at the time for new tenants, financial and everything else. From a franchisor's perspective, sometimes there's a little bit of frustration in that, well, wait a minute, okay, I get that, but we're probably the best game in town for you because it's already been upfitted for our product or service. We, are a strong company in theory at the time, right? And so you should just flip it to us. You don't have to go sell it. You don't have to bring in prospects, etc. So, and that usually works. And I tell my franchisors that have resistance from landlords that you're usually going to be the best game in town. You're never going to beat a landlord that has higher aspirations or wants to increase the rent or wants to knock down that wall, one of the walls of the unit, to make a larger space for a prospect tenant kind of thing. So, but that's just kind of a way to attenuate that, to say, okay, under certain circumstances, you should be able to say yes. And so let's put those circumstances in writing on what they may be. So, all right. And then I think, as we're kind of getting down to the end of the hour, one other thing I wanted to talk about is access of financial information of the tenant. Usually in leases, you're going to see this as a requirement that landlord can, whenever they want, ask you for unaudited financials. And their position is, well, if nothing to hide and there's not a problem, then it shouldn't be any big deal for you to punch a button on QuickBooks and spit out a report and send it to us. Usually with financial information of tenant, there is an inspection of the premises a lot of times baked into that. So not only can they look at your books, they can come into your property and look around and ask questions and that kind of thing. And so I would say that I understand the reason for that, and our leases that we draft for landlords, it has that. But we put in a lot of times what I would call fairness into that, which is, we're not, unless it's an emergency, we're not going to enter the premises without telling you first. We're not going to come in your peak hours of operation and pull your sales manager out to start asking questions as to why there is, this paint smeared on the front glass that faces the parking lot kind of thing. We're not going to ask you for financials on a whim unless we believe that there are issues with your payments. There have been issues with payments, or we believe that we anticipate there's going to be an issue with payments moving forward of rent or additional rent or of CAM or of anything else that you're responsible for. So we want to take a peek and make sure everything's going okay. So that is reasonable to do. And so, but once you breach, then I think it's fair game for a landlord to say, well, yeah, you gave us financial 2 weeks ago, but that was 2 weeks ago, and you've had business running for 2 weeks. We need to know how you're doing, and if we need to maybe start thinking about doing something differently with the space, kind of thing. So, again, we see it from both sides and understand the reasons for it, but there's ways to be fair and rebalance the ability of a landlord to just do whatever they want, but also for the tenant to be required to provide financials when there are issues that come up. So, all right, there are other things that we can talk about as well, but I mean, I'm kind of now scrolling into the boilerplate, which is also important. Just as a general statement, I think that it's just human nature. And I will tell you that, well, I don't know if Michelle feels this way. So sometimes we're our own worst enemy, because we will do what we need to do, like buying something or, getting services, and we don't read the fine print. I mean, there's some people like, okay, well, you guys are lawyers, you read everything and you know what you're getting into. It's like, no, we don't have time for that. But so I think it's even worse. It's okay. I don't want to say arrogance, but I think that if I saw something and I signed it, but I can create enough of a problem to say, well, I don't think that's enforceable, and I think it's unfair, and I think that it's an unfair trade practice, and that would be a violation of NCGS 75.1-1, and scare people into saying, okay, and so I think that all of us many times look at this boilerplate. We don't when we're reviewing contracts. I'm just saying for ourselves. And so it happens for all of you many times as well, which is you just kind of like, okay, well, it's at the back, it looks right. It's probably supposed to be there, so I'm not going to pay attention to it. But so for example, there paragraph 58 out of 60 is the guarantee language. And in this one, it's been omitted, so there's nothing there. It says intentionally omitted. But what are the conditions of the guarantee that are being given? Is it a spousal guarantee? Are there limits to it? Is it unlimited? Is it just for rent? Is it for additional rent? Is it for rent that is for the remainder of the term? And you're only in the year 2, and it's a 5-year, 10-year term. So what are you guaranteeing? Because some people would say, well, it's the company's not doing well, I'm not going to be able to get me. There's also, and we've talked about this, I'm going to make a very general statement, but don't think that you can rely on this in its entirety. But so in North Carolina and many states for real estate, there's this concept called tenancy by the entireties, which basically says if you're a husband and wife and you sign a deed as husband and wife, you get certain protections that, for example, a creditor of the husband can put a lien on the house, but cannot force the foreclosure. However, if you have both spouses sign a personal guarantee, which basically says anything that I have, I am pledging to you for this debt, then guess what? You've just destroyed that marital protection potentially. So, we try to protect against that and these kind of things. But if you like, okay, well, spousal guarantee, does that become a problem? So, look out for those kind of things. But my point is that this is the third from last paragraph that, you might get exhausted and say, okay, well, that's standard stuff. Well, not so much in this lease, right? So, I don't know, Michelle, if you have any comments about that and
Well, that and also the exhibits that are attached to the lease, they shouldn't be taken for granted. It might be site plans when you're doing your upfit, and you want to make sure that it's the correct location. And if you're going to be breaking it apart and the plans match your intentions, and they didn't grab the neighbor, grab a different units and stick it in inadvertently, speaking as from the tenant perspective, the guarantee, if there is a guarantee, the language in the guarantee is protective of your assets as a whole, as Jack said, because we've seen that, and we advise clients as a whole, like this is the risk you're putting yourself into. Husband and wife are buying into a business and then renting the space. You don't want all of your personal assets to, potentially be lost should worst case scenario. Some of the other exhibits are lists of what you're responsible for, what you're not allowed to have, what you are allowed to have. Parking is a big one, especially in the Charlotte area where parking is valuable, very valuable, because it's becoming less, it's shrinking as we're expanding. Where are you allowed to park? Who's allowed to park there? Are there fines if someone's parking where they're not supposed to? I just reviewed a lease where it was an entire page full of words about who's allowed to park where and how many spots you're allowed to have, not just for your employees. And Jack, it's not the one that I did with you, it's a different one. But not just your employees, but also the guests, your guests. So you want to make sure that if you know your business better than anybody else does, and you need to advise, if you are working with an attorney on this, advise your attorney, hey, we're only given 5 parking spots, but at any given time, non-peak, we expect foot traffic of 10 to 15 people. We need more parking. Badges to get into office buildings. How many badges before it starts costing you money for additional badges? These are little things that get overlooked because you're like, it's only $25. $25 if my employee parks in that parking space that one time. Well, your employee, you open a pizzeria, the delivery guy's getting lazy and he's parking there every day, and now $25 over the course of a month adds up. Or you thought that you were only going to have 10 employees that need badges to get into your office building, but now you've expanded and you have 40 employees. Each one of those badges is $50. do you really want to be responsible for the extra badges, or are you going to negotiate in that if your business expands and you have X number of employees, your employees each get a badge at no additional charge, and then maybe pay for a few extra for those of us who leave our badges at home every day?
Yes,
Oh.
yes. For those hypothetical people that do that or leave the badges on their desk and then have to beg the reception person to let them in. So, all right. So we're at 12 o'clock. This is probably the least amount that Adam has said on this program when he's actually here, which is awesome. But meaning that, okay, you know, it's appreciated that you're on here with us when it's not really an accounting issue. So thank you for hanging out with us, Adam, today.
I'm learning as a tenant, and I gotta tell you, you know, the nuggets, like the right of first refusal, that was pretty cool. That burned me in the butt. The cam thing, that's a big deal. And I mean, a lot of it was really good, but then the HVAC2 is like another one, you know, because like again, I'm asking for a friend, but hypothetically, if this friend was renewing in the existing building that he's in, where perhaps this friend paid for the HVAC system in his suite. You know, it's like, yeah, I want, you know, I want some credit for that. So anywho, I appreciate it, guys, definitely. So it was nice to be a learner.
So just a preview, more to come. I today was trying to get our director of communications and business development, who is in town, on the program to talk about those things, because you know they are very much in tune with social media and, you know, what is the new shiny thing that we all should be putting out there with our logo on it, kind of thing, and meaning in social media and news and things like that, and how to couch it. So that is something that she said she would be able to do, but just not today because she had some meetings. But I'm glad we were able to finish up this segment on purchase and sale agreements and leases. So, but we will be back next week with the topic du jour, and if not that one. But Michele, thank you for hanging out with us for yet another hour, and and well wishes to, and we're thinking about Gary as he goes through what he's going through today. So you know, Adam, please tell him and express to him, which I have already, but just, you know, if you do talk to him throughout the day, I don't want to bother him, but just, he knows, but just remind him that we're praying and thinking about him.
Yeah, absolutely. I appreciate it, guys.
All right.
All right. See you guys.
Have a
Thank you,
rest of the
everybody.
day. Thanks.
All right, bye.
Bye.